The Committee on Environment, Land, Agriculture, and Procurement Reform calls this public hearing to order. It is now 5:30 p.m. on Tuesday, December 11, 2018. Present with me today is Senator Michael Nicholas, and to my left is Acting Speaker Therese Terlaje. Thank you for joining us tonight. The purpose of this public hearing is to receive testimony on 3 bills. Bill number 372-34 COR introduced by Senator Therese Terlaje relative to the timely publication of all notices of violations, orders of compliance, notices of defense, voluntary compliance agreements, and referrals to the Office of the Attorney General for prosecution issued by the Guam Environmental Protection Agency, and to requiring that all voluntary compliance agreements be subject to the final review, approval, and amendment by the GEPA Board of Directors. We will also be hearing Bill number 357-34 introduced by Thomas C. Ada to exchange 324 square meters of Lot 12-2 REM in the municipality of Agana Heights with 324 square meters of Lot 12-9 REM-R4 in the municipality of Agana Heights to correct an encroachment by the Agana Heights Sports and Recreational Facility. And finally, hearing on Bill number 376-34 introduced by Thomas Ada, an act to authorize I Magaʹlåhen Guåhan to sell the remainder portion of Government of Guam Lot 12-2 REM in the municipality of Agana Heights. Notice of this evening's public hearing was provided electronically to senators, stakeholders, and the local media on December 3, 2018 and December 6, 2018, and printed in the Guam Daily Post on December 6, 2018, and the requirements of the open government law were met. We will now begin testimony on Bill number 372-34 introduced by Senator Therese M. Terlaje, and I'll ask the sponsor to go ahead and introduce the bill, and then we'll call for testimony.
Thank you very much, Mr. Chair. Bill 372 was introduced to support Guam EPA's mission to safeguard human and environmental health and promote increased transparency and open governance. It's also introduced to utilize the publication of all violations as an enforcement method to encourage compliance to environmental rules and regulations. If passed, the bill would mandate Guam EPA to publish all notices of violations, their orders of compliance, notices of defense, and compliance agreements, and referrals to the Office of the Attorney General. It would require Guam EPA to report all of these within no later than 5 working days from issuance, and it would mandate that all voluntary compliance agreements be subject to the final review, approval, and amendment of the Guam EPA Board of Directors. The public concerns that have been raised in regards to voluntary agreements were made agreements that had been made by past administrators that allowed violators to completely avoid paying fines that do not equate to the magnitude of the violation, or alternate agreements that do not serve the best interests of the people. In an August 16, 2018 Board of Directors meeting, the publication, in an August 16, 2018 Board of Directors meeting of the Guam Environmental Protection Agency, the publication of notices of violations was discussed with regard to a FOIA of all notices of violations from 2014 to the current date. It was decided that notices of violations will be published beginning October 2018 online to increase visibility and transparency. It is the intent of the bill to mandate this practice to ensure that it's carried forward regardless of any changes in leadership at the Guam EPA. And I would note that October had passed and this was not complied with yet, or at least when we looked on the website, we had not seen the publication, except for one. It's also the intent of the bill to further transparency and accountability by allowing the public to see how these violations are resolved through the publication of orders of compliance, notices of defense and the agreements and the referrals. Furthermore, by mandating a final review of all voluntary compliance agreements by the Guam EPA Board of Directors, a system of checks and balances will be put in place to ensure that all agreements are reasonable and impartial. In other jurisdictions, such as California, the California Environmental Protection Agency publishes enforcement reports on their websites as standard practice. Published data includes case numbers, date of incident, date of action, date closed, individual name, proposed action, and final actions. Data stays on the website for 2 years. I urge support of this bill as a step in the direction of increased agency transparency and accountability, and ultimately increased confidence of the public in our Environmental Protection Agency and protection of our environment and limited resources. Sidus Masti, Mr. Chair.
Thank you, Madam Speaker. Signing up to provide testimony is Mr. Nick Lee from GEPA. Mr. Lee. Mr. Perron, were you going to testify? Okay, so fine. So for the record, we just note that the chairman for the Board of Directors for the Guam Environmental Protection Agency is present at this hearing. Thank you. You can. I just wanted to put on record that you were present here at the hearing. So it's up to you.
Okay, if you have any questions,
sure.
I'd be happy to.
Okay. Mr. Lee?
Hi, Half a Day and happy holidays, Senators. The Guam Environmental, my name is Nick Lee, Acting Deputy Administrator for the Guam Environmental Protection Agency. The Guam Environmental Protection Agency stands in support of Bill 372-34. We are pleased with any legislation that assists our mission in advocating for the furthered protection of human and environmental health. The agency understands that this legislation seeks to further the agency's transparency with publishing and reporting requirements and eliminate any improprieties or appearances of improprieties by fortifying the check and balance between the agency administrator and the board of directors. The agency wishes to convey some recommendations to strengthen the bill and to ensure that we are given the proper authority to carry out the actions in the bill's provisions. Real short list, it's about 3 items. The first one, in addition to the acts listed in Section 45105, Chapter 45, Title 10 of the Guam Code Annotated, we recommend including the following acts. One is the Safe Drinking Water Act, the Guam Lead Ban Act, Water and Wastewater Operators Mandatory Certification Act, the Environmental Pollution Control Act, the Choose to Reuse Munga Ma'adzik, the Plastic Act of 2018, the Underground Storage of Regulated Substances Act, and possibly the future law resulting from Bill 236-34 relative to the above-ground storage of regulated substances.
You will be providing written testimony, right?
I just have the one call.
Oh, yeah. So just so that we catch all those additional acts that you wanted to.
Yeah. Number 2, we'd like to properly address the timeline for the voluntary compliance orders as set in our environmental rules and regulations. As an example, the pesticide enforcement program issues VCAs, voluntary compliance agreements, when an alleged violator does not contest a notice of violation. Our pesticides enforcement program rules and regulations require the agency to finalize the VCA in 10 days. And with this time frame, board review and approval may affect this 10-day requirement as set in our rules and regs, since we're bound by the open government laws with respect to special meetings that require adequate notice, publication, and quorum for the board of directors to lawfully deliberate on the VCA. Typically, the board of directors become involved in the appeal process, and that's usually when a notice of violation is contested. To this end, we recommend the inclusion of alternative language that gives the board the authority to review and approve settlement agreements as well as supplemental environmental projects that result from NOV settlements. And since the last one, since the start of FY19, the agency has committed to publishing NOVs on our website. We have gone on record to state that all NOVs issued after FY19 will be published on our site, and there is one right now. There are a couple pending review and administrator signatures, and once those are served to the violators, they will appear on our website as well. This is an administrative commitment to further transparency, and the agency welcomes the backing of statutory authority to carry out this administrative effort. Thank you for the opportunity to speak with you today.
Thank you very much, Mr. Lee. Anybody have any questions? Oh, I'm sorry. Let me defer to the sponsor of the bill.
Thanks. I want to commend EPA on their policy they had adopted during one of their meetings, and it's my understanding that was in response to a FOIA that you had received and the work that was involved in getting all the documents for that FOIA, which they were public documents anyway, that work could have been saved if they're online already and the public can have access to it. So I want to commend you for instituting this policy already. If you could just clarify, so the part of the bill that says these agreements would go to the board for their final review, approval, and amendment, you're suggesting that that be limited to only settlement agreements, not to regular voluntary compliance agreements, but only to settlement agreements that extend from that?
Oh, okay, so voluntary compliance agreements are, they offer quick turnaround. So when an alleged violator comes in and does not contest the notice, we set forth certain provisions that the violator has to agree to, and so normally the board would get involved if the NOV is contested, but in the case of a VCA, that means that the violator does not contest to the allegations in the NOV. This is to provide quick turnaround, and I understand that there is some criticism with past administrators of the agency on how the VCAs were handled. That practice has stopped in the last couple of years, particularly with this administrator over the agency. And we've moved towards something we call a supplemental environmental project. So in settlement agreement talks, a violator can defer monetary fines towards a community project that benefits the community. For example, our latest one, we have a violator who's putting up, I believe, $2,000 or $4,000 to Guam Environmental School in Harmon, and this is to go to supplies for lesson plans that relate to air pollution control. So a check presentation is forthcoming once we get everybody scheduled for that. That way, that there's no improprieties of the agency solely benefiting from any type of voluntary compliance agreement. So we've moved away from using that in that manner.
Do your supplemental environmental projects normally come together with a fine, or you're saying in lieu of a fine?
The violator, in settlement talks, the violator is afforded that opportunity, but there are some guidelines that the agency takes into consideration. If a administrative penalty order is placed on the violator, there has to be a form of payment for that environmental infraction. So a SEP, supplemental environmental project, a SEP cannot completely serve as an alternative to paying for an administrative penalty order.
Did you say it does or it does not?
Does not.
Does not.
Yeah.
Okay. Okay. All right. And so then, yeah, I've tried to write this bill so that it didn't restrict you from moving forward with your voluntary compliance agreements before you get the board together, but that they were ultimately subject to some final approval by the board.
That's correct, and we had some concerns over that, mainly with the timing that is set in our rules and regs. And the example that I spoke about tonight about the pesticide enforcement program that gives the agency 10 days to complete the VCA. When you look at trying to schedule with the Guam Daily Post or whichever publication we choose to announce the special meeting for the board to deliberate, that takes away a considerable amount of time from that 10-day period where the VCA has to be finalized. So we're a little bit concerned that advertisement delays, quorum delays may compound that situation where a VCA won't be settled within the 10-day time frame that exists in our rules and regs. Yeah.
Right. Well, I'm trying to make it the language, and maybe the board or you could give me language that could improve this. But I was trying to write it so that the administrator goes ahead with the voluntary compliance agreement. That's normally between the administrator and the violator, I guess. And
right.
And they go ahead and they sign that and they move forward. But at the next board meeting, they would have a whole list of whatever's happened that month, or right?
That's usually entailed in the administrator's report. Yeah, so that's usually detailed in the administrator's report, right?
Right. And so I'm just trying to make it so that it's subject to their final review, approval, and amendment, so that if they find anything that they think should be changed, or that they just feel is not proper, that they are able to do something about it at that point. I'm trying to empower the board to be a check and balance at this point.
Right, and that's part of the reason why we're recommending that the board have the authority over the settlement agreements. Because as it stands, that is a conversation between the violator and the administrator. So to further the check and balance system between the administrator and the board of directors, that could be something of benefit to the agency.
Okay, is that the exact title of those settlement agreements?
I'd have to double check on that, but that's kind of the in-house vernacular that we use.
Yes.
It's a settlement agreement.
And that document is not the same as the voluntary compliance agreement.
That's correct. It's not. Okay. The main differences are the violator does not contest when they enter into a VCA, and the violator contests when they enter into a settlement agreement.
All right. I thought, if I recall, maybe I don't have the facts in front of me, but that most of those, there were a couple of these cases that garnered some public attention because, for example, the initial fine that you cite in the notice of violation is up to $50,000, and then the final arrangement was something much less than that. Was that not pursuant to a voluntary compliance agreement?
No, those
would be a settlement agreement?
Yes, that's part of the settlement discussion.
Okay, then I couldn't find that settlement agreement in the statute. So if you could show me that authority or what you use for that,
okay,
we could try to fix it, Mr. Chair. Mr. Perron, did you have anything to add?
Yeah, we discussed the bill today at our board meeting. We had a board meeting just prior to the public hearing today. So we discussed the bill itself, and then the concerns that legal counsel and the administrator had, which was highlighted by Nick. And we stand in support of the bill, and we think it's good policy to have checks and balances, and to have at least two sets of eyes on these types of things to make sure that everything goes properly and nothing is missed, and that the public has confidence that things are being handled fairly and evenly across the board. So the board of directors are in support of the bill. with possibly legal counsel coming back with some possible ways to cover a few things that may not be covered. So again, we are in support of the bill. Yeah.
Thank you very much to both of you for your work and for your testimony. Thank you, Mr.
Thank you. Thank you. Senator Nicholas.
Thank you, Mr. Chair. Thank you for making time to be with us tonight. Just a couple of questions. The board, how often does the board meet?
We meet monthly on the third Thursday of the month.
Do you guys have a quorum usually? Is it?
Usually, but in the last few months, we've had a couple of terms expire and they didn't get their paperwork in time to be confirmed, you know, but basically that was on the board members themselves that didn't get things turned in. But normally, in the normal course of business, we do have quorum, although we're getting a little bit close now. We only have 6 members currently of the 9 that constitute the board.
And just out of curiosity, the agency will still be able to operate if there was no board. Is that correct? And the reason why I'm asking is because, I mean, statutorily, are you only able to operate with a board? Or if there is, like, let's say, for example, the board is unable to fill all of its vacancies, they're unable to make quorum, the agency does continue to operate. Is that correct?
My understanding, the Enabling Act the Enabling Act for the agency may require the board. I'd have to double check that,
right.
but that would be my concern with your question.
And the issue that you run into if you don't have a quorum is if somebody contests a notice of violation, you have 60 days to set a hearing date and hold the hearing on the contested NOV. And if that time frame isn't met, then the NOV would be dismissed. So.
Right, and actually what we'll be doing here is, for example, on page 7 of the voluntary compliance agreements, they shall be subject to final review, approval, and amendment by the board. And so if, for example, the board is unable to constitute, then we won't be able to have any kind of final approval on any of these voluntary compliance agreements. Yeah. And so theoretically, if all the terms expire and if the governor does not appoint board members, then we can have voluntary compliance agreements sitting in the agency indefinitely.
Correct.
Okay, that's just one concern I wanted to raise. Another concern I wanted to raise was with respect to all of these items here that shall be published. Now, I'm very big on transparency, but I also want to make sure that everyone's afforded due process before they're being kind of stigmatized by the community. And so, forgive me for not being as familiar with these various elements here. But at what point are we talking about something that has yet to be fully adjudicated in terms of what's supposed to be published versus what has already been fully adjudicated at the agency level? So, for example, are notices of violation only issued after they've been adjudicated fully, or is it the beginning of the adjudication process?
Notices of violation are issued once the administrator signs off on program review of the violation. Without this law, our administrative practice is publication occurs after the violator has been served with the NOV and after the notice of defense period has already lapsed. That might be what, 15 days? 15 days. So we do give the regulated community that type of due process, and we'd probably take this up with our legal counsel just to make sure that we're not violating any laws, particularly if a confidentiality agreement or clause takes effect, or anything having to do with attorney-client privilege throughout the settlement talks. But generally, we look at what the FOIA law dictates, and we go from there in this administrative process. Yes.
So, for example, someone gets a notice of violation, right? what's their next step after that?
They can file a notice of defense, and that's when they can appear before the board, or they could, hopefully they can admit to everything and we can wrap it up as quickly as we can. There's a third option that, or I think the notice of defense and or flat out denying everything. I think that's the third option. So once the NOV is signed, there's an acknowledgement portion on that gets returned to the administrator, and that sheet tells the administrator if the violator contests or doesn't contest or wants to defend themselves before the board.
And so, have there ever been any instances where a notice of violation was issued and somebody came in and presented a defense before the board, and it was found that the notice of violation was actually dismissed? And the reason I'm asking this is because, if we're going to publish a notice of violation before they've actually been able to provide for their defense, I'm concerned that it's going to stigmatize whoever the affected party might be, without them having actually been afforded the opportunity to remedy or provide explanation for what the notice might be related to. So has there ever been an instance where there was an erroneous notice, or maybe to the wrong party, or maybe a violation that was cited that turned out to be actually properly defended by the party that was violated or noticed to be violating?
I've only been with the agency for 2 years, and in that 2-year span, I don't recall any instances like how you're describing. But
yeah, I believe previously there was a few successful defenses of an NOV that were dismissed at the board level. I can't recall the exact circumstance, but I've been there about close to 16 years, and it seems to me there was an occasion or two, maybe 8 to 10 years ago, where there were some things that came to the board that we didn't agree with, the way that they were written up and the action that was taken.
Okay, and so they would receive the NOV, the notice of violation, and then they would be given an opportunity to defend against that notice of violation with a notice of defense. What about orders of compliance? I'm trying to figure out the sequence here. NOV, NOD, and then orders of compliance, or how does it work here? I'm referencing page 3, lines 11 to 17. That kind of, they outline all the different things that we shall publish. So the NOV is the first thing that happens.
Right. So we put the alleged violator on notice, and we point out the statutes that they're allegedly violating. Orders of compliance is our way of telling them, look, this is an egregious act. That you have to take these steps immediately. Or I do know that some of the environmental statutes that we have do carry criminal penalties. So that may be something that we definitely need to be looking into. But the order of compliance is the agency giving the violator the corrective action that needs to take place to cease the infraction.
So they'll get the notice of violation, basically saying you're violating something. Mm-hmm. Orders of compliance saying this is what you need to fix because of that violation, and then a notice of defense saying if you don't think that our orders are correct, you can come before the board and defend yourself.
Right. There are some instances, however, where we do attach the APO, the administrative penalty order, and that's an assessment of the monetary fines that the violator is liable to pay. As the acting speaker pointed out earlier, there are statutory maximum amounts that we do inform the violator of. When we determine a figure to place on the administrative penalty order, we take into account the statutory facts of the case, whether it was an egregious act or whether it was negligence or accidental. We also look into the violator's willingness to comply with our orders, and we look into, how quickly the violator came into compliance. So all those things get factored in determining an administrative penalty order amount.
And Senator, after they come to the board, they can still go to Superior Court if they're not happy with the decision that the board renders. So there's still another step beyond the board if the violator feels that he's still in the right and wants to take it one step further.
Okay. What I'm trying to really clearly do is very clearly draw the line between the accused and somebody who's actually been adjudicated, and they're going through now, being assessed a fine or what have you. I'm concerned about just publishing somebody being accused because they haven't had the opportunity to go before the proper adjudicating authorities and perhaps explain or justify why they feel that they're not in violation of whatever it is they're being cited for. But after they've had that opportunity, if the board or if the administrator or whoever the deciding authority is still renders after they've been adjudicated that they are in fact in violation, I'm okay with publishing that because they've been afforded a form of due process. But if we're just going to be publishing notices of violation prior to any due process, I'm concerned that, you might get a green EPA employee one day who goes out and cites 10 people, and it turns out that, that was actually a mistake. But they get published, and then it gets, put out into the media, and then all of a sudden these parties are getting stigmatized in the community for, a violation that might not necessarily have had merit.
Right, but because the administrator signed that document, it's still something that the public has the right to inspect. So whether the medium is sending us a FOIA or Joe Cruz walking into the agency requesting to inspect those documents or seeing it online, those are the types of avenues that the public has to get their hands on this information. So I don't know what the future of this bill is going to be, but if there is a requirement for us to remove it off the website because a violator was found to be in compliance or not in any type of violation, then we can do that. But that document would still exist in the agency. It would still be subject to interpretation by our regulated community and the media. But I can see where you're going with that, and that was something that our legal counsel did discuss with us prior to us committing to publish these things on the site.
Let's say, for example, that you're company X, right? And you're trying to bid for a federal contract that has very stringent environmental concerns, and they Google your company and they find on the website that you had a notice of violation, but they came before EPA and they were actually able to have that properly adjudicated, and was found that they actually did not have a cause for concern. There's nowhere in the mandate that says that those published notices actually have to show that they were adjudicated and found in the negative. And so I'm just concerned that, we don't want to, as much as we want transparency, we also don't want to create circumstances that are unjust to parties that, turn out to not be violating when they were originally cited as being violators. So those are just some of the concerns, Mr. Chairman, that I wanted to raise. Like I said, I'm okay with us publishing something that has already been adjudicated, even if there's still further adjudication steps. But, it's almost like the police blotter. You have people, and I've always had mixed emotions about that, because you can have somebody's name show up on the police blotter, but then all of a sudden, no one ever follows through on the story later on that they actually went to court and they were found not guilty. But yet, as our community, especially of this size, it's not hard for word to get around that so-and-so was on the police blotter, and then all of a sudden you just have somebody who's unfortunately a victim of not being able to have that stigma removed because they were presumed to be guilty when they were in fact innocent. So those are just some of my concerns with the bill. I do like that it requires that the board receive all the notices. I'm surprised that that actually needs to be written in. I would think that that's a standard practice. But just those items, Mr. Chairman, the adjudication, the stigmatization, and then the issue of quorum and the board having to have final review and approval and amendment of the settlements or the agreements, that could create a problem because, as you know, Mr. Chair, we do at certain points and sometimes rather consistently, unfortunately, in this government, have a lot of boards that don't meet quorum. I mean, we even had a point in time where the parole board wasn't even meeting quorum, and you would think that something as basic as parole would be continuously meeting quorum, but that also started to pose its own challenges. So I just wanted to raise that concern also, that we may have agreements that would have been settled or would be moving forward, except for the fact that there was a lack of quorum. So those are just some of my concerns of the bill, but I do appreciate the intent for additional transparency. Thank you, Mr. Chairman.
Thank you very much, Senator. That's it.
Can we just clarify again? So your current policy is to put online all notices of violations?
All notices of violations issued after FY19.
Okay. And at what date? When do you put them on? After service upon the violator, you said?
And after the 15-day time frame to provide a notice of defense has elapsed.
Okay, so service plus 15 days. So you wouldn't publish it without knowing whether they're defending or not?
That's correct.
Okay. I would have no objection to amending the bill to read like that, to be consistent with how you've decided is proper. And all these documents that we've listed in the bill that should be published, these are all public documents.
That's correct.
Anyone going to EPA should be able to access these. The public should be able to access these at a board meeting if, after this law, I mean, even now, if they were reported to the board. But I wanted to point out that this is where this came from, right? This is where the FOIA came from. It was, we had discovered, or they had discovered that there was a violation that had been settled, and it was not reported in the media for maybe over a year, I want to say. And so the community was so surprised at the settlement. They thought it was unjust. They thought it was too, that the penalty was too small compared to the violation. But I looked at what you guys had done, and it just seemed to me that really the gap was just the public didn't follow along, right? They were made to feel like they were kept in the dark until you had settled the whole matter, right? And then they see the end result, and it looks like we're being complacent or lax in our enforcement, right? But I don't think that's necessarily the case. And I just think if they were able to follow along notices of violation and defenses, this is very common practice. And I can't imagine that, the theory that the board might not have a quorum, that's the same theory that applies right now to your statutes, right? That requires the board to be there for appeals. And so, I mean, so many boards, the parole board, like he said, these boards are necessary for the proper functioning of these agencies, for regulatory agencies especially, for their review. So, and if it's only twice in the last 18 years that a violator has won their appeal, it still wouldn't remove the requirement that all the documents in that case would still be public. We would still know that you had given them notice, and I think a notice of violation. I think the most important part that if you could both just explain for the public, these notices of violation are not issued lightly. You said they go through program review, they go through the administrator's review, and so maybe you could just explain that, because I just know from experience that EPA, they really do their due diligence before they issue the notices of violation, and that they're they're not likely to put somebody's name out there for violating something if they're not able to prove that, or have what they think is proof of it.
So we could address that through the agency's outreach efforts, talking about how the notices of violation work so that the public better understands that. That's something that we are developing for our permitting process. So we could address that issue by way of better outreach.
What type of review does a notice of violation undergo? Who issues it? Is it the news person at the EPA who's issuing the notice of violation? Or you said it was the administrator. So what kind of review does it go through before the administrator signs?
So the notice of violation can stem from, depending on which statute is being broken, it could stem from an anonymous complaint or multiple complaints for somebody who wishes to go on record, or an observation made by an agency member out on the field. So that incites an investigation, and so depending on the responding program's statutory authority dictates the type of investigation that occurs. So once the investigation is complete, the responding program writes up the NOV and the orders of compliance for the administrator to review. So yes, there is a lengthy process to this, and we like to think that it's as thorough as it needs to be. It's case by case. Not every case presents a certain set of challenges that the program has to address. The responding program has to address at least. If there is no need to issue the NOV, then the agency does not issue it. But we do our homework on this, and the administrator does scrutinize the work from the complaint to the investigation to the findings to the write-up of the NOV. The administrator does scrutinize these documents and these details before putting his signature on the NOV for it to be issued to the violator. So once it leaves the administrator's office, usually the responding program goes out and serves or issues the NOV to the responsible party.
All right. Thank you very much. Unless you wanted to add something, Mr.
Well, I think it's important that the disposition of the case be online as well. The violation, and then what became of it. The fine, or it was dismissed, or whatever, just to complete the circle. So I think it's real important that the whole story be told, and not just the notice of violation and the accusation, but the final disposition is important too, to be in there, just in case, like Senator San Nicolas said, that the violation was issued mistakenly, and then it can be explained in there why it was issued and what the mistake was, and that the violator has been cleared of any wrongdoing. So I think that's important as well.
Yes, I agree. That was our intent. So could you help us, if in addition to the settlement agreement, if that's the title, right? And is there another document that shows the final disposition that we may not have listed here?
I'm not sure if there's an official form. There might be a letter of finding, but I don't know that there's a legal description of it. But it's probably something that we could
but we will
come up
commit
with.
To publishing documentation relative to the finality of the case. I failed to mention that in my testimony.
All right. So
that's
maybe
something
we'll
that we
also
will
add
do.
in the bill that final disposition in, like, not capitalized because it's not a formal form, but just something that indicates final disposition, right?
Right.
All right. Thank you very much. Appreciate it, Mr. Chair.
Thank you. So there being no further comments or questions, we'll consider Bill 372-34 as having been duly heard. Thank you very much. Next up is Bill 357-34, And this is an act to authorize the exchange of 324 square meters of government land with the same number of square meters of government adjacent private property to correct an encroachment by the Agana Heights Sports and Recreation Facility. So signing up to provide testimony is Mayor McDonald and Mr. Edwin Torres. Mayor McDonald. So Mayor, we'll start with you, since it is your sports facility that has been encroaching into private property, which we're seeking to rectify by basically exchanging private land and allow you to keep that space that your facility is encroaching into. So please proceed with your testimony.
Okay, Mr. Chair, good evening, Senators. Thank you for allowing me to testify. I am Mayor Paul McDonald. I'm here to testify in favor of Bill 357-34. You know, it's been almost 100 years that we've had use of a portion of the tourist property. And you know, we're very grateful, and I have some pictures that go all the way back to 1956 that show of the use of the property. In the bill, it specifies that about 30 years. This 30 years is the time the baseball field was updated. It was, lights were installed, and the backstop was installed, permanent backstop, permanent lights. And before then, it was, we were looking at this picture that I believe you have, okay? And this picture is actually in 1949. When the Agana Heights baseball players came up and built the field in part of the property of the Tauruses. So that it's very important that we settle this now, because the Tauruses have finally subdivided their property. And they found that it was identified in the map that you also have attached to the bill. In 1995, a couple of years after I took over the mayorship in Agana Heights, we introduced and passed a resolution that I can't find anymore. It's too many years away, and the record is lost. But at that time, we did submit a resolution to the legislature and the governor, and indicating that there was an encroachment when we had asked land management to come in and conduct a survey. But at that time, the property wasn't subdivided yet in 1995, in that time frame. But now that it's been subdivided, it's showing now who owns that part of the property that is shown on this map that we have here. So, you know, to correct the wrong, this is why I've asked that we entertain this bill and that the Municipal Planning Council is in favor of this bill totally. And, you know, we owe it to the Torreses to settle this property. And that's my testimony for this bill. Okay.
Thank you very much, Mayor McDonald. Mr. Torres.
Good evening, Senators. My name is Edwin J. Torres. Dr. James H.P. Flores, owner of Lot 12-9 Rem-R4, is authorizing me tonight to represent him at this public hearing. I would like to thank Senator Ada for introducing this bill, as well as the entire committee for extending this opportunity to provide testimony on Bill 357-34. Before addressing the merits of Bill 357-34, I think it would be helpful to the committee if I were to provide some background on the two bills, because it is difficult to discuss them individually without knowing how they work together. The two bills tonight, Bills 357-34 and 376-34, address the exchange of land to compensate Dr. Flores for the government's encroachment onto his land, and the sale of the surrounding land to be exchanged for the encroachment. Bill 357-34 provides the exchange, while 376-34 provides the sale. The Torres family owns the majority of the land surrounding the exchange by Bill 357-34, and by extension, the land to be sold by 376-34. As the committee can tell from the map attached as Exhibit A to Bill 376-34, the Torres family owns 12-9 Rem-2 all the way to 12-9 Rem-R4, which is the property being encroached by the government. The Torres family also owns 12-1-2-1 new-R1, as well as 12-1-2-R1 as indicated by the map. In addition to these marked by the map to be owned by the Torres family, the family also owns lots 12-1-1, 10-11, and a large portion of 10-21. The Torres family is the majority shareholder of private land that abuts the property to be sold, and by extension, the property that's going to be exchanged. Now, with some background, I want to move on to addressing the merits of Bill 357-34. For the past 30 years, the government of Guam has encroached on land owned by Dr. Flores. The dugout and bleachers of the Agana Heights baseball field, as well as numerous power poles, have occupied Dr. Flores' property and prevented from enjoying the entirety of the property. The family has always been and remains committed to the village of Agana Heights and supports the village's use of the sports facilities, and has not at any point prevented access from the government or the public to use the dugout or bleachers. The dugout and bleachers have no access point but through the property owned by Dr. Flores, and the family has always allowed the public to use the property. In an effort to create a solution that would be both agreeable to the government and the family, the Torreses have attempted for the past 30 years to work with the government to create a solution to address this injustice. But such efforts have been to no avail until today. We believe that Bill 357-34 is an adequate solution that addresses the interests of both sides. The land that will be exchanged, 324 square meters of Lot 12-2 Rem, is land already connected to Dr. Flores' property. It is land that has not been developed by the government. It is government property that currently provides no meaningful benefit and will provide likely no foreseeable meaningful benefit for the government. Exchanging this part of 12-2 Rem will compensate Dr. Flores for the encroachment. It will allow the dugout and bleachers to remain with the village of Agana Heights, and it will not disrupt the public's use of the sports facilities. And it will also provide an increase of revenue to the government through the exchange land becoming taxable real property. In closing, Bill 357-34 will compensate the family for the injustices that have occurred because of the government's encroachment, ensure the village of Agana Heights continues to have access to its sports facilities, and increase the government and Guam's revenue through former government land becoming taxable private property. We humbly ask the committee to support Bill 357-34. Thank you, Senators, for this opportunity to address the committee.
Thank you. I'm going to go ahead and we'll go into, let's clarify whatever questions we may have regarding Bill 357. Now the committee members or the panel members should have do you have this, Senator? Okay. So basically then the area that is enclosed in the, do you have a copy of what we're looking at? So the area that's bounded in blue is the private property that the sports facility is encroaching into, and that consists of approximately 324 square meters. So we're proposing, now the land 12-2 REM is government property, so what's being proposed by Bill 357 is to then exchange that portion that the sports facility is encroaching into with the area that's bounded by the brown or the gold boundary, the same area. So that is what Bill 357-34 proposes to accomplish, the exchange of the 324 square meters as shown here, the blue for property that's bounded by the golden by the yellow boundaries. Does anybody, do you have any questions, Senator Nicholas, on that particular proposed exchange? So essentially then the exchange will decrease the government property 12-2 REM by, it will reduce it by 324 square meters.
If I just could point out for the record, Mr. Chairman.
Sure.
While the exchange is area for area, the family is exchanging an area with improvements for an area without improvements. The orange has no improvements on it.
It's just raw land.
Right. Okay.
And actually, the area that's enclosed in blue currently has the floodlights. Correct, Mayor? In the where you're encroaching right now, you have in there a couple of the concrete poles, the tall floodlights. And do you have bleachers also up in that area? And then further behind the bleachers is an area that is normally used by the people using the sports facility for barbecuing or gathering after a game activity, correct?
Yes.
Okay. So actually there's, so the only improvement in the blue area is the installation of the floodlights and the bleachers that's on there. That's the extent of the improvement. I've actually gone up there to take a look at that property.
And the jogging area, the sidewalk that goes totally around the baseball field.
Correct, yeah, okay.
Yeah.
The jogging path.
Mm-hmm.
All right?
Yes.
With that as a background, I think I would like to go ahead and go into then Bill 376-34. Bill 76-34, using the same graphic, shows it proposes to then sell the remainder of 12-2 REM, Government of Guam property, to the Torres family. Mm-hmm. So I believe your testimony for Bill 376 is pretty much the same as for 357, or there's some differences to it?
There's some differences.
Okay, go ahead and read your testimony, please.
Thank you, Senator. As for the public record, my name is Edwin J. Torres, and I represent Edwin F. Torres, and the Torres family is one of their attorneys. The land that will be sold under Bill 376-34 is land owned by the government of Guam that does not provide any benefit currently. It has no access from the public road, and the close proximity to the baseball field likely prevents any meaningful development for the government that would bring foreseeable revenue. The bill is meant to address this loss to the government by allowing the Torres family to purchase Lot 12-2 REM. As indicated by my previous testimony, the Torres family is the majority owner of private land that abuts Lot 12-2 REM. As such, the Torres family is committed to ensuring the government obtains adequate compensation for its sale of the property. And to fulfill that commitment, the family has decided to pay twice the amount of the appraised value of the property. Thus, if Bill 376-34 were to be passed, the government will, in addition to increased taxes from the property becoming taxable land, obtain a sizable amount of revenue from the sale, which would be given to the Chamorro Land Trust pursuant to the bill. We believe this bill will greatly benefit the government of Guam, and we humbly ask for the support. Thank you.
All right, thank you very much. So we have this graphic here, and you indicated in your testimony that the Torres family owns, that's contiguous to the government of Guam land 12-2 REM, which is shown up there on the screen, bounded in yellow. That's the government of Guam property 12-2 REM, which would be the remainder if we go through with the exchange to correct the encroachment. But I just want to verify who are the owners of the contiguous lots. So 12-1-2-1U-R1 belongs to Thomas Lannon and Robert J. Torres, correct? Do you know if Mr. Lannon has any interest in buying a portion of 12-2 REM? Turn on your microphone, please.
I believe Tom Lannon was the former trustee of the Robert J. Torres Trust, but he has no interest anymore. He's since passed away. There's now a new trustee of the Robert J. Torres Trust that owns the property.
So in essence, 12-1-2-1U-R1 technically belongs to the Torres family.
That's correct.
Okay. 12-1-2-R1 also is property contiguous to the property that's being proposed to be purchased, belongs to the Torres family.
Correct.
Correct. The other contiguous piece of property is Lot 10-21. Now, in your earlier testimony, you indicated that the Torres family is the majority shareholder of private land that abuts the property to be sold.
Correct.
Can you clarify that?
Yes, so 10-21, a large portion of that is owned by the Torres family.
Belongs to the Torres family.
Correct.
So there's no one else outside of the Torres family that owns an interest, owns property that is contiguous to 12-2 REM. Is that correct?
I'm sorry, I made a mistake earlier. 10-21 is a large portion of it is owned by the Torres family. I'm not sure exactly how much is owned by a different private landowner, but a large portion of 10-21 is owned by the Torres family. I do not know who else owns part of 10-21.
So 10-2 lot 10-21 is not one large lot?
I do not believe so.
Okay, I find that a little problematic because normally what happens when government land is to be sold, the opportunity is given to contiguous landowners to also get an equal share of that if they wanted to buy into that. And so if it is not clear just how much of 10-21 belongs to the Torres family and how much belongs to another family, then we would need to clarify that.
Sure.
So well, maybe we may be able to get clarification on that before the end of this session. And until we do, it may be hard, may be difficult to move forward with Bill 376-34 till we get that clarification. However, I think it is clear about the encroachment issue that I don't believe there's any issues with that, and we could move forward with Bill 357 to do the land exchange to correct the encroachment issue. Does anybody have any questions? Okay.
Thank you, Mr. Chair. Just a few questions, or maybe some comments, and then we can move forward. On the, I just wanted to note for the record that the statement tonight from the families that they are willing to pay twice the amount of the appraised value of the property. I just wanted to put that on the record because we just recently come out of dealing with some other land bills where we were very consistent with staying to what the pricing will be on GCA, which is the average of 2 appraisals, but the family is willing to pay double the appraised value, just for the record.
That is correct.
Okay. The question with respect to the adjacent lot 10-21, do you know if 10-21 has been subdivided?
I do not know.
Okay. I think that's a critical question because based on the maps that we're looking at here, 10-21 looks like a contiguous lot. And if there's multiple owners of the contiguous lot, I think the way that it works is you just need to get all the multiple owners to sign off that they're okay with the transaction to sell that particular lot, or that they're not going to pay, or they're not going to compete on the basis of price for that particular lot. But I do understand the requirement is that all of the landowners need to be afforded the same opportunity. So, and that's a real question because if you look at the, with an aerial photograph of the map, there are I see 2 structures here on 10-21, but the survey map does not show a subdivision of 10-21. And so it may be a good idea to just figure out who the actual owners are, because if 10-21 is being leased, but if the actual land is owned by the Torres family, then there's no concern with respect to adjacent landowners. Just another item to point out, Mr. Chairman, is the families indicated they're willing to pay twice the amount of the appraised value of 12-2 REM. But if we look at the map provided on Bill 357-34, 12-2 REM encompasses both the concrete sidewalk and the cockpit, but the survey map that's identified on Bill 376 actually carves out the sidewalk and the cockpit area. And so it will be almost a, where the orange rectangle is on Bill 357, that's where the lines will be drawn for the 12-2-REM. So I'm assuming then that section there that includes the concrete wall will be, what's the word, surveyed out of the existing 12-2-REM and will continue to remain with the government. And so that would still also provide easement access all the way through to lot 10-21. So I don't quite know how that plays into the question of adjacent property owners if they're still allowing for easement access. But Mr. Chairman, if I may reference, do you see what I'm talking about here? This is what they're talking about purchasing, but this is the entirety of 12-2 REM that includes this wall here. So they're going to carve that out, but still pay double the price for apparently the total. Right. So I just wanted to put on those particular items on the record. I wanted to thank the family for letting the community use that lot for as long as they have. You know, that you could have been paying property taxes on that lot for all we know. But at the very least, you know, the community has been able to utilize the property without having to pay any kind of leases or incur any kind of costs. And it's, you know, it's a sports facility. It's good for our community. I think that it behooves us to be as accommodating as possible with respect to the land exchange. And in the question of the purchase transaction, I did want to note that absent this purchase transaction, I think that this property, Mr. Chairman, might actually be landlocked, if I'm not mistaken. Because if you look at the lots surrounding it, 12-2-REM, the lots surrounding it are all privately held. 10-21, 12-1-2, 12-1-2. There would be access as a result of the exchange, but right now there is no access unless the exchange is consummated. But even that access as a result of the exchange is technically not accessible because we have bleachers and floodlights and infrastructure in that exchanged area. So, you know, when we're contemplating whether or not to move forward with this transaction that also involves a generous offer of double the appraised value, we're talking about a landlocked piece of property, a landlocked piece of government property. So, just some elements to consider, but I respectfully yield to the chair in regards to the request for the certification from all of the landowners of Lot 10-21. Thank you, Mr. Chair.
Thank you very much, Senator Nicholas. Senator?
Thank you. Mr. Mayor, you have a copy of this map that has the exchange parcels. There's so the blue encroachment area that you want to obtain is cut out of, there's this kind of an odd-shaped parcel of land there. What does that constitute right now? Is there a road there? Is the parcel that you are going to obtain going to include the road?
Yes.
So would this connect you to the current easement?
Yes.
All right. So
this would allow us to get to the cockpit area.
okay.
And the sidewalk that goes
And
around.
what about the front of it? Where does it connect to?
Will get us to left field, outside the fence of the baseball field.
Doesn't this connect to the area near the mayor's office? No?
No. This is the
I mean, the one edge of it. How would you enter this area?
through the school and through the front of the mayor's office.
Okay, that's what I meant.
Yeah.
All right, so that part there.
Yeah.
You see that odd-shaped parcel of land, or any one of you who could answer that? What? You're not getting that whole thing. You don't need that in order to connect to the access. The access is not clear here. That's why.
Is that government property there just below the 12-9 REM-4? So there's it looks like a butt stock for a gun.
Oh.
Right below the blue bounded area. That's government property, correct?
Correct.
And your backstop is to the right of that.
Yes.
Okay, so this is all government property.
Yes.
Okay, I want to make sure.
And then the square shaped thing there is your building, your community center, correct?
The square?
Yes.
No, that's part of our grandstand or whatever it's called.
Oh, is it? Okay, yeah,
The
all right.
bleachers, yeah.
Okay. But then around that area is your community center,
Yes.
and then over to the right would be your
Gym.
your gym.
Yes.
Okay. So all this
Oh,
around
yes.
here is the government, the sports facilities, and this community center and the gym.
I guess I would, Mr. Torres, Attorney Torres, if you
Yes.
could, yeah, just also chime in on this. So you see that it's a gun-shaped looking parcel? Mm-hmm. Yet the government, the mayor's not asking for all of it. What happens if he doesn't get the rest of that gun-shaped parcel?
Do you mean this portion here?
Well, to the left of the blue.
I think this gun shape here.
Here, can you come up? Can you
To
come
the
up
left
here
of-
so she
to
can
the
show
left
you?
of the blue line, I mean, there's still a part of that gun-shaped parcel. This part here. So what's going on there? Yes, no, right here. So above the blue line, there's still part of this gun-shaped parcel. Why is that parceled off? What about this gun-shaped thing? I'm curious if he's cutting it right here, what is he not getting? Is that part of the road or something like that?
Where's
All right. So that's one question.
Can you answer the
Oh, sure.
question here?
You know, I think that's the showing the street.
That's what I'm curious if it's part of the road and you're not obtaining the whole road here.
It's part of the dirt road. It's just to indicate that there's a dirt road in there. Yeah.
All right. I guess, yeah, what I'm trying to make sure is that the part that the mayor's going to end up with actually includes what he needs, including if that's an access road, that it includes that part of the road. And it seems to be outlined somewhat, so we could just get clarification on that later. And then my other question was, so Mayor, you're very clear that obtaining this area is going to allow you access to the back field. I mean, the back unused lot right now, right?
Yeah.
Actually, it's used by the cockpit and the sidewalk. Okay. And then, so this exchanged parcel is going to be exchanged with Dr. James Flores, who's, okay, and then the buyers of the remainder of the property, you say you represent Edwin F. Torres.
Correct.
And so the bill mentions that the landowner's Edwin F. Torres, but the maps don't say that. The maps say other Torreses. Maybe you could clarify, is this a probate that's been divided?
I do not know that, how but I do know that Edwin F. Torres does own this property here.
Which property?
12-1-2-R1.
The sketch that we have shows Frank Torres as the owner of 12-1-2-R1. That's this piece up here.
Correct. I don't know how old this map is. I don't know what the date is on this map, but Edwin F. Torres is the current owner of this parcel.
So I guess the committee is going to have to get an updated map that shows the correct landowner.
Sure.
If you think that Frank F. Torres is not, or Frank Torres is not the...
You know, this may be a mistake here because Edwin's middle name is Frank. So Department of Land Management may have mixed up Frank Edwin Torres, which I assume is maybe what's happening here.
Oh, very good.
Yeah, that might be it.
Okay, yes, if we could just get clarification of that, because we're trying to ensure this is being sold to an adjacent landowner.
Correct.
So we want to be able to confirm that. And then just if you could please clarify, so your testimony says you represent Edwin F. Torres and the Torres family.
Correct.
What do you mean by Torres family? Because there are other Torreses who are also adjacent landowners, right? So the Robert J. Torres Trust?
Correct. So I'm one of the attorneys that also represents the Robert J. Torres Trust.
Okay, and so they agree to this being purchased by
Correct.
Edwin F. Torres. And James Flores
Correct.
Dr. Flores also agrees that it be purchased by Edwin F. Torres.
Correct.
So just as an example, we had recently another bill that sold government land, and the contiguous landowners, there was different landowners, and what was required was that the contiguous landowners had to basically write out that we have no interest.
Sure.
And then that then freed up that sale to go to the one party that's interested in buying it. Although they were really from the same family, but they were different,
Individuals.
There was so we're going to need to do some work with the committee on this, get some clarifications, possibly even get some of the contiguous landowners to basically execute a document that says we have no interest in buying.
Sure.
Okay.
If I could ask you just, Mayor, also, so the exchange is very clear, the purpose and all that, but after the exchange is completed, you will have access to this back property, and you're currently using it for cockpit, according to the map, maybe other things. And I guess I'm just wanting to ensure that, all the other mayors are coming in here asking us for more land from the Chamorro Land Trust so they could use it for their villages. And so I'm concerned that Agana Heights is giving up this land to be sold, even after the exchange of property. It can complete the exchange and obtain the portion that it needs and still be able to use this lot. So I'm curious about any other purposes for Agana Heights to use this property. After all, it's going to be getting access.
Senator, this piece of property is actually in the middle of all residential areas. And we had actually not used this cockpit for many years already because of the proximity of where it's at. So we've actually not used that
vacant government land?
Right.
Okay.
And like I said, because of the close proximity to the residential area, it's just not viable for us to even go in there and disturb that area because it's so serene. It's all residential areas. I'm in a residential there. People living there, and they want their privacy, and I don't see any facilities to go up there. You know how it is in Agana Heights.
Okay, well, I'm just concerned because Agana Heights is not that big, and any property I would think, is necessary. All right.
And if you look at we have everything there, all the sports facilities there, and it's not big enough to even build a basketball court, and the topography of the property is not level. It's kind of hilly.
Well, you already have a basketball facility in your gym, correct?
We have
an indoor
facility.
In
and outdoor. We have two.
Oh, you have an outdoor also?
Yes, a basketball court across the baseball field.
Okay. Okay.
Yeah.
All right.
So we have two basketball facilities.
Okay.
And it's busy every night.
All right.
All right. Did Agana Heights have a pending request for a senior center, or that's already incorporated in this?
We have one.
Near the mayor's office?
Yes.
Yeah, all right. Thank you. Thank you, Mr. Chair.
Okay, thank you very much. I don't have any further questions, but I would ask that work closely with the committee staff so that we can get some of these questions answered about, for example, the ownership of lot 10-21, and then the issue about, the what we have here on the map that we have different Torres members listed on here. We have a Robert Torres, we have a Frank Torres, are listed here as owners of the lots that are contiguous. So we're going to need to get with tomorrow with the committee staff so that we can get this clarified. Okay?
If they come by my office, I can give them the information
Yes.
for the owner of that one piece
Okay.
of property.
So we open at 8 o'clock and you
8
can
o'clock.
come in then. Thank
Yes,
you.
sir.
Thank you very much. All right.
Thank you very much,
so
Senator.
with that, we'll deem bills 357 and 376-34 as having been duly heard. Thank you. And with that, it is now 6:55 and this public hearing is adjourned. Thank you.